previously served as Chief of Staff of the President's Council of Economic Advisors and 2 years as Deputy Executive Director of Domestic Policy Council, a Bachelor of Arts in Economics from Swarthmore, and a Master's from Oxford. Thank you for joining us, Ms. Fruchtgott-Roth, and we look forward to your testimony.
Thank you very much.
Is this going to be a power presentation?
No, it isn't. Mr. Chairman,
PowerPoint presentation?
Mr. Chairman, members of the committee, I'm honored to be invited to testify before your committee today on the subject of Judge John Roberts and his record on women's economic issues. I followed and written about these issues for many years. And with your permission, I'd like to submit my written testimony for the record.
Without objection, it will be made a part of the record in full.
Some observers are concerned about Judge Roberts' attitudes towards women. I believe his record is supportive of women and that the policies he advocated are in women's best interests. Women made extraordinary progress during Ronald Reagan's presidency. President Reagan's goals of spurring growth by lowering taxes were extremely popular. After Congress enacted his tax cuts during his first term, he was re-elected in 1984 with over 60% of the vote. Congress then enacted further tax cuts proposed by President Reagan, and by the end of his presidency, the tax rates for the median family had fallen from 24% to 15%. As taxes were reduced, the economy expanded, and women were some of the main beneficiaries of that economic growth. In the 1980s, women moved rapidly into the workforce. At the same time, their unemployment rates fell. Women's earnings compared to men's grew faster in the 1980s under President Reagan than in any other decade in U.S. history. Women also progressed in education in the 1980s. By 1990, women were earning over half of all BA and MA degrees. That's still true today. More women got MBA and law degrees, and more became doctors and lawyers. Now the United States leads the industrialized world in job creation, and unemployment rates at 4.9% are among the lowest. Unemployment rates for women in many other countries are double our rate. Even though women were so successful in the 1980s, some are concerned about Judge Roberts' views on comparable worth. Some believe that if comparable worth had been implemented, women would have made even more progress. But that concern is misguided. Comparable worth doesn't mean equal pay for equal work, which is already the law, and which is the principle that President Reagan and Judge Roberts supported. Instead, comparable worth means equal pay for entirely different categories of jobs, based on categories of workers determined by government officials. Comparable worth supporters claim that it's unfair that some mostly male occupations, such as sewer workers, are paid more than some mostly female occupations, such as clerical specialists. But for better or for worse, our economic system rewards American workers on the basis of how much the public values their service and is actually willing to pay for their services, not based on how much an official says that it's worth. Some jobs have higher earnings than others because people are willing to pay more for them. Many jobs are dirty and dangerous, such as oil drilling, construction work, mining, and roofing. These jobs are primarily performed by men. Women aren't excluded from these jobs, but they often choose careers with a more pleasant environment and potentially more flexible schedules, such as teaching, communications, and office work. Many of these jobs pay less. Proponents of comparable worth cite an example in Oregon. There, female clerical specialists were given raises of over $7,000 a year to bring them in line with male senior sewer workers. Everyone, given a choice of working in an office or a sewer at the same salary, would choose the office. You just have to pay people more for work about and in sewers. Women's progress in the 1980s would have been hampered by comparable worth. Comparable worth would have worked against women because artificially high wages would have prevented them from being hired. When wages get too high, employers cut back on numbers of workers. Comparable worth assumes that women cannot ever succeed in certain fields on their own, but need government assistance. Some observers have criticized Judge Roberts because they disagree with memoranda he wrote on Title IX and college athletics in the early 1980s. In particular, Judge Roberts wrote in 1982 that Title IX only applied to specific programs receiving federal aid and not to all programs in a particular educational institution. But that was what Title IX required at the time, as corroborated by the Supreme Court in 1984. The Supreme Court ruled that only the program that actually received federal funds, rather than the entire college or university, need comply with Title IX. As I wrote in a book in 2001, the 6-3 opinion effectively prevented the Office of Civil Rights of the Department of Education from investigating a college athletic department for Title IX violations unless that department was the direct recipient of federal funds, which most were not. In writing about Title IX, Judge Roberts argued persuasively that the executive branch and regulatory agencies should comply with Congress's direction. He correctly wrote in a 1982
Ms.
memo.
Roth, could you summarize your testimony at this point?
Yes. I will summarize my testimony by saying that Congress changed the law in 1987 by passing the Civil Rights Restoration Act of 1987, and that Judge Roberts's comments on Title IX, if the law had been in place in 1982, his comments would have been very, very different. And in short, I'd like to say that wage discrimination laws and Title IX guidelines aren't a decision for judges, but for members of Congress. It's members of Congress who decide on the laws and give the executive branch the authority to design and implement these regulations. Therefore, it would be up to you, senators, to evaluate the costs and the benefits of the issues. And should he be confirmed as Chief Justice, Judge Roberts' role would be to interpret the laws and adjudicate disputes containing the laws that you were going to pass. Thank you very much.
Thank you. Our next witness is Professor Robert Reich. Had been Professor of Social and Economic Policy at Brandeis until he recently joined the Goldman School of Public Policy at the University of California. He served as Secretary of Labor during President Clinton's first administration. Subsequently published a book entitled Locked in the Cabinet. Before taking office during the Clinton administration, was a member of the faculty of Harvard's Kennedy School of Government, BA from Dartmouth, Master's from Oxford University, where he was a Rhodes Scholar with President Clinton, and a law degree from the Yale Law School. I'm pleased to see you again, Professor Rice, Mr. Secretary Rice. I have some questions left over which you didn't answer when I questioned you when you were Secretary of Health and Human Services, which we will get to promptly.
That's because I was Secretary of Labor, Mr. Chairman. Mr. Chairman and members of the committee.
No wonder I couldn't understand what you were doing.
I have prepared testimony, and with your permission, I'll submit it for the record. There's been much discussion in these hearings about social values. And I want to put on the table something that maybe has not received quite the attention it should, and that is economic values. And I don't think I have to tell the committee what almost everybody knows, and that is that wealth and income and the power that come from wealth and income are more concentrated in fewer hands as a proportion of the population today than we've seen since the 1920s, and by some measures since the Gilded Age of the 1890s. Now, if this doesn't present issues of economic morality, I don't know what does. And it comes to the fore with regard to Congress and the Supreme Court in a whole series of protections, some of them very old, some of them going back to the 1920s and 30s and 40s, having to do with workplace protections, unemployment insurance, interpretations of Social Security, interpretations of minimum wage, the ways in which we treat our working people in this country. Now, I heard Judge Roberts, at least to the best of my memory, in the last couple of days, tell this, that he would rule on the side of the little guy when the Constitution told him to, and he'd rule on the side of the big guy when the Constitution was on the side of the big guy. Now, I assume that he's talking about little guy and big guy in figurative terms, in terms of economic power and wealth and status in society. But last time I looked at my Constitution, it doesn't say anything about average working people or big guys or little guys at all. In fact, there have been times in our history where the Supreme Court came down consistently on the side of wealth and power and against little guys, against average working people. Up until 1937, for example, the Supreme Court threw out a lot of state and federal regulation that was intended to help average working people. Judge Roberts has a record. It's not much of a record, something of a gamble for all of us. But let me reveal a little bit of autobiographical detail that perhaps you didn't know, and I do this not to burnish my otherwise impeccable Republican credentials, but simply to tell you that I know something about a particular institution. I started out my life in government as assistant to the Solicitor General, where I had a chance to brief and argue Supreme Court cases. And my first boss was Robert Bork. Now, in those days, the Solicitor General's office regarded its primary client as the Supreme Court, not the administration. It wasn't until the mid-1980s that there was a new position created in the Solicitor General's office called the Special Deputy. That was a political position. It was a political deputy, and it was about values. That political deputy was there for a very simple reason: to make sure that the Solicitor General's office and the briefs and arguments before the Supreme Court were in consistency, were consistent with the values of the President in terms of social values, economic values, whatever have you. I've read Judge Roberts' memoranda, and there's no question in my mind, having had that experience in the Solicitor General's office, that he came down consistently, uniformly, on the side of very conservative economic and social values. I'm not criticizing him for it, but I think it's very important that you know that. Here, in this hearing, he said, for example, he refused to affirm Wickard against Fillmore. Now, you know as well as I do, over the last 10 years, more than 30 times, the Supreme Court has struck down, either in whole or in part, laws of this Congress. 10 of those, at least, have been based on the Commerce Clause. Wickard against Fillmore, in my knowledge, in my experience, is a cornerstone of building the protections of a strong federal government for average working people. His refusal to affirm that, I find personally quite troubling. There's been reference also to the hapless toad. Well, we know that he was looking for other ways, perhaps, to find that Endangered Species Act constitutional. But look at that logic in that particular case when he says Congress didn't really have authority under the Commerce Clause to protect the life of a hapless toad that, for reasons of its own, lives its entire life in California. Well, obviously, people are not toads, at least the last time I looked. But what about protecting the job safety of a hapless retail worker who, for reasons of her own, lives her entire life in Pennsylvania, or a hapless coal miner who, for reasons of his own, lives his entire life in West Virginia? Let me just finally say this. One justice can make all the difference to our entire system of federal protections. One justice. The court did change its mind in 1937, as I said before, and it stopped striking down laws that protected people, average working people, not because, as popularly understood, FDR threatened to pack the court. No, in fact, the court made that switch before it even knew that FDR had a court-packing scheme.
Professor Rice, could you summarize your testimony at this point?
I will do it in one sentence. The justice who made that switch was Justice Roberts, Justice Owen Roberts. And it would be a cruel joke of history if a namesake almost 60 years later turned the court backward. Thank you.
Thank you very much, Professor Rice. Our next witness is Rabbi Dale Polikoff, President of the Rabbinical Council of America, whose membership consists of more than 1,000 ordained rabbis. He serves as rabbi of Great Next Synagogue, Long Island, faculty member of the North Shore Hebrew Academy, graduate of Yeshiva, where he majored in psychology. Thank you very much for joining us today, Rabbi, and we look forward to your testimony.
Thank you, Mr. Chairman, and other distinguished members of the committee. Good afternoon, or perhaps good evening. Thank you for inviting me to participate in these hearings. Rabbinical Council of America includes congregational rabbis, teachers and academicians, military chaplains, some of whom serve today in Iraq, Afghanistan, and other areas of the world, healthcare chaplains, organizational professionals, and others. I am here this afternoon to offer a statement of support for the nomination of Judge John G. Roberts to be Chief Justice of the United States. My remarks about Judge Roberts begin this afternoon with broad brushstrokes because the desired qualities of judges within the Jewish tradition are defined in just such broad brushstrokes. We are enjoined to choose principled judges who refrain from showing favoritism to individuals or causes. We seek judges who are people of truth, whose words and decisions inspire confidence in those who rely upon them. Our tradition recognizes the tremendous responsibility borne by those who judge others and sees in their dispensing of truth and justice a divine partnership ensuring the continuation of a moral society. At a time in which many in our society seek moral moorings and spiritual strength, I am certain that these broad values are also the values embraced by this great country in which we are privileged to live. Values of principle, values of truth, and values of responsibility are part of the foundation of religious ethics upon which our nation has been built. And I am confident that Judge Roberts represents the embodiment of such values. Within these broad brushstrokes, though, are many hues of color. And it is the responsibility of this Judiciary Committee to try to determine how Judge Roberts sees those colors. As the representative of the clergy of a minority faith community, I and my colleagues are also interested in an area of seminal importance to us, namely the relationship between religion and state in society. In an effort to gain insight into Judge Roberts' understanding of that relationship, as defined by the free exercise and establishment clauses of the First Amendment, we were encouraged by a memorandum written to Counsel Fred Fielding on August 20th, 1984, regarding remarks to be made by President Reagan to an ecumenical prayer breakfast. Then Counsel Roberts suggested that the references to church or churches be changed to references to religion or religions. He noted that, and I quote, "Many of our citizens do not worship in churches, but in temples and mosques," end quote. We believe that this comment demonstrates a sensitivity and appreciation for the diversity of religious faith in America, and we hope is a harbinger of Judge Roberts' view in this crucial area. There are those who suggest that Mr. Roberts' subsequent participation in presenting the view of the United States in several religion cases should be of concern. In this matter, we rely on the guidance of the Institute of Public Affairs of the Union of Orthodox Jewish Congregations of America, a sister nonpartisan religious organization. Their research indicates that in each of the cases, the positions advocated by the United States were neither extreme nor even unreasonable interpretations of the religion clause's requirements. As members of this committee are well aware, the contours of religious liberty in this nation are still being shaped by the Supreme Court. Should the Senate confirm Judge Roberts, he will be on the court this term, when in the case of Gonzalez v. Ocentro Esperita, it will again examine the extent to which minority religions will have their religious liberty protected against government interference, and Congress's ability to protect that liberty through laws like the Religious Freedom Restoration Act, which many of you championed a decade ago. While we cannot be certain, we are optimistic that a Justice Roberts will be supportive and solicitous of religious liberty in America. His answers this week to questions you and your colleagues have asked him about the Constitution's religion clauses were indeed reassuring. The Rabbinical Council of America has taken this public position of support for the nomination of Judge Roberts in the spirit of this year's celebration of 350 years of American Jewish history. The Jewish community, like so many other faith communities, has greatly benefited from the religious liberty guaranteed by our Constitution. We have been able to build houses of worship and study, and to create communities reflective of our values and traditions. We believe it thus appropriate, through our active participation in this process, that we acknowledge our debt of gratitude to America, to a nation that has pledged to uphold the conviction that liberty and equal justice under law are for all. Thank you very much.
Thank you very much, Rabbi. Our next witness is Dr. Susan Thistlethwaite, president of the Chicago Theological Seminary. PhD from Duke University, Masters of Divinity, summa cum laude, undergraduate degree from Smith, the author of several books and op-ed pieces in various newspapers. Thank you for joining us, Dr. Thistlethwaite, and we look forward to your testimony.
Thank you, Chairman Specter and members of the committee. My name is Susan Brooks Thistlethwaite. I'm president and professor of theology at Chicago Theological Seminary. My academic training is in historical theology. My teaching and writing have emphasized contemporary religious life with particular attention to religion and social justice. It's an honor to be asked to give testimony before the Senate Judiciary Committee, and with your permission, I will submit it for the record. Our Constitution's promises, such as the right to live free of tyranny and be able to worship freely, are generous, even extravagant promises. They are promises made after freedom had been won from tyranny, a tyranny both political and ecclesiastical. They are promises made to the best of the human spirit as created by God. In the limited documents available to discern John Roberts' views, there is evidence, and I have cited detail in my written testimony, that his judicial posture is more toward permissiveness in religious establishment and is less than vigorous in the defense of religious minorities and their freedoms. He refers to the so-called right to privacy, has objected to affirmative action, but has favored expanding both the authority of law enforcement and presidential authority. Very disturbing to me is the view, and I quote, "The Geneva Convention is unenforceable in U.S. courts and in any case does not apply to detainees labeled enemy combatants." I submit to you the threat to the moral health of the nation of this view is extremely grave. A Supreme Court justice entrusted to interpret the Constitution must embrace the fundamental element of our democracy. We will strive to be a body politic rooted in justice and fairness for all citizens. A justice trusted to interpret the Constitution must understand that the protection of the free exercise of religion and the prohibition of any establishment of religion are particularly critical to the way in which this Constitution promises to establish justice. Few Americans have understood the promises inherent in our Constitution better than Dr. Martin Luther King, Jr. Dr. King, in his I Have a Dream speech, was able, as few before or since, to reach into our constitutional past and proclaim the deep sense of the words that the Constitution was a promissory note to which every American was to fall heir. King argued that so far this promissory note to African Americans had been returned insufficient funds. But the promise held. The promise for King was a dream, but not a fantasy. Dr. King's vision, as is well known, was a deeply theological vision. It is perhaps less well known that the framers of the Constitution also drew on a theological vision, and that their prohibition of the establishment of any religion and their insistence on the protection of the free exercise of religion was made for religious reasons. The thought of John Locke, on whose work the Founding Fathers, such as Thomas Jefferson, drew, is instructive. Locke, like others in the 17th century, had seen the terrible results of religious wars as Catholics and Protestants struggled for power in England. His own faith finally led him to believe that it is only in the absolute protection of human civil society from any control by religious authorities that people are enabled to come to have faith in God. It was for a theological reason, not a secular one, that both Locke and Thomas Jefferson separated church and state and prohibited establishing one religion over any other. In that way, they protected religious freedom. In Jefferson's A Bill for Establishing Religious Freedom, he argues the plan of our holy author of our religion is not to propagate it by coercion. They made the simple point: God does not need the help of the state for there to be faith. From our vantage point in the 21st century, we can see the framers were right. They did not just protect political freedom, they protected religious freedom. It is no accident that the United States, through all of its history so far, has been free from the terrible effects of religious war. The framers of the Constitution knew what they were about. As retiring Justice Sandra Day O'Connor wrote in an opinion last term, those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well from one that has served us so poorly? What has become evident in the last half of the 20th century and into the 21st is that our society is becoming more genuinely religiously diverse. The Harvard Pluralism Project has documented that the United States is rapidly becoming the most religiously diverse nation in the world. Such increasing religious pluralism calls for even greater vigilance, both in protecting religious minorities and clearly avoiding even the appearance of the establishment of any particular religion. The Constitution is a document that seeks to implement a vision of fundamental human rights, a vision of a society such as none in history had seen before, a vision that would establish justice, promote the general welfare, and secure the blessings of liberty. I have been impressed with the incisive mind of John Roberts. That is a necessary but not a sufficient credential for Chief Justice. I am not as convinced that he believes in the dream that is the United States of America. Thank you.
Thank you very much, Dr. Thistlethwaite. We now turn to Governor John Engler, President of the National Association of Manufacturers, the largest industrial trade group in the United States. Served as governor of Michigan for 3 terms, and before that had extensive experience in the Michigan State Legislature. Chairman of the National Governors Association, a graduate of Michigan State, and a law degree from the Cooley School of Law. Thank you for coming in today, Governor Engler, and the floor is yours.
Mr. Chairman, Senator Leahy, and distinguished members of this committee, I'm pleased to be here today to testify in support of the nomination of Judge John Roberts to the next Chief Justice of the United States Supreme Court. This is an important moment for the National Association of Manufacturers because it is the first time that we've participated in a proceeding of this type. I would like to take a minute just to explain why we've taken this historic step. When I joined the NAM on October 1st of last year, I did bring that experience you referenced, 20 years in the Michigan legislature, 12 years as governor of Michigan from '91 to 2003. During that time as governor, I found that Michigan businesses were facing crushing legal costs and barriers. I also learned and saw firsthand laws that I'd helped write in the state Senate or signed as a governor were in many instances ignored, rewritten, or set aside by judges unclear about or dismissive of their sworn duties. In part because of this, the legal environment for doing business in Michigan had become unpredictable, unfavorable, and unacceptable. As a governor, I set out to change this by recruiting to the judiciary individuals who were committed to uphold the law and not legislate from the bench. During 12 years as a governor, I appointed more than 200 judges to the Michigan courts, and that included 3 state Supreme Court justices, each of whom has a record of faithfully interpreting and applying the law. Now, as a result of these appointments, coupled with equally needed and important tort reform legislation, cases filed in the Michigan Circuit Courts dropped by some 17% between 1997 and 2004. The legal cost of doing business in Michigan declined. The people of Michigan, through this debate and period of time, came to understand that the certainty and predictability the judges help foster when they follow the law not only can lead to a better business climate, but necessarily then are a key to jobs and prosperity. The same can be true at the national level. Nationally, our legal system today consumes some 2.3% of GDP. Its cost is actually about 7.5 times as high as that of any of our key trading partners. The high cost of lawsuit abuse continues to be an impediment to our ability to compete in the global economy. Now, of course, much of this solution to this doesn't lie with the federal courts, but in state legislatures, in Congress, which must write clear laws that recognize these realities. And that's why the NAM continues to advocate asbestos reform. It's been the subject of much hard work by this very committee, and further tort reform in areas like products liability. Now, that said, to achieve a business environment that is fair and predictable, and where the rules are clearly spelled out and adhered to, it's essential to have judges who will apply the rules the legislature or the Congress establishes in a fair and predictable manner. The United States Supreme Court must set the example. The need for this fundamental fairness and predictability is why the NAM decided that the time had come to take positions on judicial nominations. After reviewing Judge John Roberts' record, we're convinced he's eminently qualified to lead the court. Judge Roberts has the intellect and the experience needed to understand and address complicated transactions and difficult legal problems. At the same time, he's committed to applying the law rather than applying his own personal views. This philosophy is essential if we are to remain a nation guided by the rule of law. Finally, John Roberts understands the importance of clarity when deciding cases and the practical consequence of decisions for business. Now, I might add that really none of the current members of the court come from a recent private sector kind of background. Judge Roberts does. He brings that. Accordingly, if confirmed, Justice Roberts will add an important voice to the court's deliberations because of his strong experience of how litigation affects major commercial transactions. This background will allow the court and assist the court really in identifying cases that present business issues of national importance for its review, and also in understanding the practical ramifications of rules set out through its decisions. As I close, let me make it clear that the NAM also didn't seek to determine if Judge Roberts will reach or is likely to reach a particular outcome favorable to business. The principal difficulty with an outcome-based approach is that the outcomes a justice should reach ought to depend on what the duly enacted law is. In many areas, different companies and businesses will disagree on what the pro-business result actually is. Therefore, the National Association of Manufacturers is not looking for a justice who's biased in favor of or against business, or whose decisions reflect or are likely to reflect a pro-business outlook, but rather for a justice who will properly and impartially apply the law. We're convinced Judge Roberts is such a justice, and I respectfully urge this committee then set in a timely manner his nomination before the full Senate. Thank you, Mr. Chairman.
Thank you very much, Governor Engler. Our final witness is Ms. Karen Pearl, Interim President of Planned Parenthood Federation of America. For 10 years prior to becoming the Interim President, she was the President and CEO of Planned Parenthood of Nassau County. She has been a preschool teacher working with children with disabilities and has a master's degree in counseling from New York University. Thank you for coming in today, Ms. Pearl, and the floor is yours.
Mr. Chairman and distinguished members of the committee, I am Karen Pearl, Interim President of Planned Parenthood Federation of America. I am honored to be here today to express the concerns and hopes of our patients and America's pro-choice majority. I come before you not as an individual, but as a representative of millions. Through Planned Parenthood's 850 health centers, we provide health services to nearly 5 million women, men, and young people every year. 1 in 4 American women will visit a Planned Parenthood center in her lifetime. These women represent Americans from every walk of life and from every part of the country. What is at stake in these hearings is nothing less than women's lives and women's health. Americans deserve a Supreme Court that will protect, not take away, our basic freedoms. The record of John Roberts reveals a nominee who, as Chief Justice, is not likely to uphold constitutional protections for the right to choose abortion. And while we have fought hard for that right, and will fight just as hard to protect it, Planned Parenthood does everything in our power to reduce the need for abortion. Yet there are forces at work in this nation who seek to restrict comprehensive sex education, contraception, and emergency contraception, the very things that would decrease the number of abortions in this country. In his response to questions from some of the members of this committee, Judge Roberts has refused to state that he accepts and will protect a woman's constitutional right to choose, a right that has been part of the fabric of our society for nearly 2 generations. We ask that you oppose his nomination to the lifetime position of Chief Justice of the United States Supreme Court. 5 years ago, in Stenberg versus Carhart, 4 of the 9 justices made it clear that they support either overturning Roe v. Wade or significantly gutting it. To do so would seriously threaten constitutional protections against government regulations that threaten women's health and safety. To do so would send us back to a pre-Roe era, where women did not have an equal place at life's table, and when making childbearing decisions was a perilous enterprise. The American people deserve a Chief Justice who will uphold Roe. And yet Judge Roberts co-authored a brief filed on behalf of the government in Rust v. Sullivan that stated Roe was wrongly decided and should be overruled. It is hard for me to understand, Senators, how a decision that for the past 3 decades has helped women participate equally in society could have been wrongly decided. It is hard for me to understand why a decision that allowed women to realize their dreams should be overruled. We at Planned Parenthood are faced with the prospect of violence and intimidation every day of our lives. My first day on the job at Planned Parenthood, a sign was posted on the front door that threatened, "Anyone who enters will be killed." And as I volunteered as a clinic escort, violent protesters hit us with their signs. In the Bray case, Judge Roberts was one of the authors of a brief arguing in support of the legal position of violent clinical protesters. Nowhere in the brief did the government disavow the actions or the tactics of the violent demonstrators, not even in a footnote. When women's health centers in Wichita, Kansas were being blockaded in 1991, a district court issued an injunction against the protesters to protect women who were attempting to enter the centers. Judge Roberts was involved in a highly unusual intervention that sought to lift the injunction, even though the injunction was preventing violence and safeguarding women. This week, Judge Roberts repeatedly refused to answer whether he will protect the basic rights and freedoms of all Americans. Senator Specter himself pointed out that Roe has been reaffirmed by the Supreme Court multiple times. Notably, Judge Roberts has acknowledged that there is a right to contraception. He is comfortable making these statements, but he steadfastly refuses to acknowledge the same about the right to abortion. As a legal matter, we believe that the right to choose abortion is as settled a fundamental right as the right to contraception. No one should be confirmed to a lifetime position with the power to take away the right to choose who does not accept that proposition. When Judge Roberts answers questions about Griswold and Eisenstadt, but refuses when it comes to Roe and Casey, Judge Roberts is drawing lines of convenience, not rules of law. No matter how remarkable the person or impressive the resume, a nominee for Chief Justice ought to be able to tell the American people whether the Constitution allows states to ban abortion. Judge Roberts has refused to do so, even when pressed by you. We still do not know whether a Roberts court would preside over the creation of 2 Americas, one where women with means can obtain abortions even if they are not legal, and one where women without resources cannot. When our patients' safety is at stake, when the ability of families to make personal,
would you summarize at this point, please?
Private decisions about their lives is at stake, when women's status in our society is at stake, accepting anything less than clarity would simply be irresponsible. You all know that Justice Harry Blackmun wrote the majority opinion in the Roe v. Wade decision. In the decades following that decision, as more justices on the court ruled to overturn Roe, Blackmun wrote, "A chill wind blows." His words echo hauntingly today. Senators, I urge you to not confirm Judge John Roberts as Chief Justice, and I thank you so much for the honor and privilege of addressing you today.
Thank you very much, Ms. Pearl. Just a few questions. The hour's growing late. Ms. Pearl, the hearing has dealt extensively with the concerns that you have addressed, a woman's right to choose, and it boiled down really to Judge Roberts' statement that he felt he could not speak to that issue as a matter of judicial independence in a context where there are cases on the docket which raise the issue, unlike Griswold, which has been pretty well established as a right to privacy, something I asked him about and others did. Do you think that, I know you'd like to have an answer, people who want to overrule Roe would also like to have an answer, but do you think there's any basis for Judge Roberts' statement that he simply cannot prejudge the matter before it comes before him as a matter of independence, judicial independence, and that he can't sell his vote one way or another? There are people on this panel on both sides of the issue. I think we're divided among the 18, 9-9. Mm-hmm. Doesn't he have a point that he can't prejudge the case?
Senator, thank you. I don't think that is correct. We are not asking him to prejudge any case. We've not presented him with any facts of any particular case.
But you're asking him to say he would sustain Roe versus Wade's woman's right to choose.
We are asking him whether the precedent that has been established and, as you said, reaffirmed 38 times, is settled law of this land, established rights. You know, women have counted on that right for almost 2 generations, for 32 years. It's hard to believe that that is not something that ought to be considered settled law. It was the Roe decision that was only 1 year after the Eisenstadt decision. So the time frame shouldn't matter, and it has been looked at so many more times. This is the decision, the question of whether and when to become a parent is such a fundamental right that it is hard to believe that it is even open for any kind of question. And if Judge Roberts was willing to talk about the right to privacy as it relates to contraception, he ought to have been able to talk about it as it relates to abortion. Reproductive rights are simply not to be negotiated.
Professor Rice, going back to your JD from Yale, what is your evaluation of the issue of judicial independence and not soliciting votes on this committee or in the Senate by a promise one way or the other on Roe versus Wade when the issue is on the docket for the Supreme Court in the next term?
I think it's entirely dependent, Mr. Chairman, on how settled the case is. That is, if you have something that is a super duper precedent, as you repeatedly talk about it, then it would seem to me entirely appropriate for a candidate, a nominee, to say, I would follow a super-duper precedent, just like Wickard versus Fillmore. On the other hand, if it's up in the air, if it really is up in the air, if there are a lot of 5-4 decisions, it's likely to come before him, he doesn't want to reveal his cards right now because it would be inappropriate, then it's a different story. In this case, it seems to me that Roe v. Wade is the law of the land. It's been there for many years. Why can't a nominee simply say clearly, I support Roe v. Wade as the law of the land?
Well, unlike the right to privacy or contraceptives for marriage or for single people, there's a great debate. I don't have to describe it for you, a great debate in this country about the subject. If the definition, if it's up in the air or settled, I don't think, as you heard me say, that we could ask him about his decision. But on the factors which Ms. Pearl articulates, he testified he would give them great weight. It's really unpredictable as to what any nominee is going to do. Who would have predicted that Justice Kennedy would have supported Roe versus Wade? The cases are legion in the history of the court. The only consistency is one of surprise. Rabbi Polikoff, has your organization taken a position on any Supreme Court nominees in the past?
No, Mr. Chairman, we haven't, but we feel that in a generation, and certainly in today's society, with traditional values and religious ethics threatened, that it's important for there to be a spiritual voice added to the hearings by this distinguished group, and that's why we're here today.
Governor Engler, my time's almost to expire, but I have time for a question. Does this mean the National Association for Manufacturers is going to become more politically active, like supporting asbestos reform?
You can count on that, Senator.
Thank you very much. Thank you very, very much. Thank you super duper much.
I thank you, and I'm hoping that the expeditious conclusion of this matter will allow a little bit of floor time for that important topic.
This committee has done its job.
It has indeed.
Now it's up to the floor time of the leader, Senator Leahy.
I am so tempted, but I will withhold.
Senator Hatch.
Let me ask, Ms. Pearl, let me ask you the same question I asked Marcia Greenberger, for whom I have great respect as well. Since Justice Rehnquist, or even before, has Planned Parenthood ever approved or endorsed or accepted or been favorably disposed towards any Republican nominee to the United States Supreme Court?
Thank you, Senator. I'd like to start by saying that Planned Parenthood does not make these kinds of decisions on any kind of partisan basis. It's not that we approve or disapprove of Republican nominees, approve or disapprove of Democratic nominees. To your specific point, however, I am mostly certain, and I am very happy to go back and check and send you a letter to confirm that Planned Parenthood did not take a position on Justice Sandra Day O'Connor's nomination to the Supreme Court.
But that's the only one you can recall.
That is the one that I recall right now, yes.
I know your group is a close ally of the National Organization for Women, they've testified, I think, in almost every one except this one. Both of your groups, for example, I think are members of the Leadership Conference on Civil Rights.
We are not.
You're not, okay.
We actually have an application pending.
Now opposed Justice John Paul Stevens' nomination in 1975, saying his record showed he would, quote, bend over backwards, unquote, to limit the right to abortion. We all know that didn't happen. Now opposed Justice Anthony Kennedy's nomination in 1987, saying his record shows a, quote, total lack of commitment to equality and justice under law, unquote. I had a flyer that I saw circulated in 1990 by the National Organization for Women opposing the nomination of David Souter. It says, stop Souter or women will die. The reason I raise this is because, as we all know, these justices have supported abortion rights. I personally don't know where Justice Roberts is on that issue, and I don't think you do, nor do I think anybody else does, because he has never really opined on it. Now, you cite cases where he was working for the Reagan administration, which clearly was against Roe versus Wade. But he was a staff attorney making the legal arguments that they wanted him to make, which is quite a bit different from saddling him with that particular philosophy. Now, it turns out that the absolute and categorical certainty of those positions against Justice Stevens, Kennedy, and Souter were just plain wrong. And see, that's where I'm having some difficulty here. Did your group participate in the Stop Souter rally that advertised on that flyer that went out? Did you participate in that?
I do not know the answer to that.
Well, I don't either, but I seem to recall that Planned Parenthood did, and they had a right to if they wanted to. It's just that that was wrong. And so what I'm saying is, it's one thing to think a person may be going to vote a certain way on the court, but you don't know how Justice Roberts will vote. I don't know how he will vote. You may be right. You may be wrong, as Planned Parenthood, well, I think Planned Parenthood was part of it. Now, the Alliance for Justice, the NARAL, the Leadership Conference on Civil Rights, they were all wrong on those 3 justices. Now, if we make these decisions solely because somebody thinks somebody might not live up to what they think as the law should be, there'd be very few people ever privileged to serve on the United States Supreme Court if both sides started to play that game. So all I can say is this, is that your organization is a great organization. I don't agree with some of the policies, but I've also supported you with regard to some aspects of the work that you're trying to do, but not on the abortion side of it. But it seems to me that there's a responsibility to not prejudge people who have the eminent qualifications that Judge Roberts has. And that worries me just a wee bit. But I've been interested in your testimony and certainly have listened to it, and as I have to all of yours. I welcome my old friend Robert Reich here. He's always a controversial person who makes us all think more all the time, and you have done it here again today deliberately, I know. And I do respect you and appreciate you, and I like alternative points of view. I think that's a good thing for our society. And you certainly present plenty of them for us to think about up here, both Democrats and Republicans. But thank you, Mr. Chairman.
Thank you, Senator Hatch. Senator Kennedy.
Thank you, Mr. Chairman. I welcome the panel, and I particularly welcome Bob Reich. He's been a long-time friend. I've been a great admirer of all of his strong commitment to public policy and public life generally. It's been an extraordinary career for he and his wife as well, who've shared a strong commitment to public service. Dr. Reich, let me ask you, the Judge Roberts, in one of his statements, said the courts are passive institutions. Is that how do you react to that as a concept? Is that your view about what the courts are, what the courts can be, what the courts should be, in trying, in particular, to help the country respond to this extraordinary challenge, which all Americans are reminded of this past couple of weeks with Katrina, when we sort of tore back the fabric of America in the Gulf states and saw so many people that have been left out and left behind. We're not talking about handouts. What we're talking about is a hand up. And shouldn't the courts be a part of a process and where the executive and the Congress and the courts are moving in harmony to try and make this a fairer country and a more equitable land? And if that is so, what's your reaction to the comment that the courts are passive institutions?
Senator, the courts are not passive. Anybody who watches carefully, reads Supreme Court opinions, looks at the history of the Supreme Court, understands that they are far from passive institutions. Interpretations of the 14th Amendment, Equal Protection Clause, have historically changed the face of this nation in terms of bringing minorities and women into the mainstream. When I was Secretary of Labor, one of my duties was to implement the Family and Medical Leave Act. Well, that was a hard-fought piece of legislation. You know, you were actively involved. First piece of legislation passed by the Clinton administration that we got through, at least signed into law by Bill Clinton. Well, we did some regulations pursuant to that. Some common sense regulations struck down by this Supreme Court in a very close 5-4 decision, it seems to me, I believe I'm right, said that that particular regulation simply required that an employer notify an employee of his or her family medical leave rights was inconsistent with the purpose of the Act. Well, a judgment that a particular regulation is inconsistent with the purpose of an Act is not a neutral, passive decision. The court is an active instrument of public policy. It has values, social policy, economic policy, and look at, Senator, all of you, I understand, this is a tough one. This is a roll of the dice. I mean, you don't have, there's not a lot, there are not a lot of decisions, not a lot of court decisions. There's some memoranda you had difficulty getting from the administration, a lot of pieces of information. But, and it's presumptuous of me to tell you what to do, but the stakes are so huge here for the country. I don't see how you can, in good faith, given that the court is not a passive institution, turn the country over to a court, and it will be turning the country over to a court where you just don't know what's going to happen.
Well, I was somewhat disappointed that in the various areas of public policy where Judge Roberts had been so active. I mean, he had obviously solicited the job to serve in the administration. He was selected by the administration to serve in the Justice Department, and he felt very comfortable ideologically being there, all of which is I respect, and his commitment to public service, but he wanted to be in there, and he felt very comfortable, and he was promoted all the way through there. So he had these series of memorandas stating administration position, and there was always the question whether this was just stating the position or what percent of this was his own views. The point that I thought was somewhat disappointing was asked is, given that was 20 years ago, what was your position today on these issues? And it seemed to me to be pretty ordinary that people would say, look, those were my views then, those are the administration. Today I look at X, Y, and Z, whether it is on the issues of civil rights, whether it is on women's rights, whether it was on the issues on Grove City, which was always amazing to me after we had fought through all of the Civil Rights Act that an individual could feel, and with all the money that was going to universities with tuition, which was keeping them running, that you would have an individual that would say, well, we want it just program specific. So if they don't discriminate in the admissions or the financial office, the admissions office, they can discriminate wherever they want at the university. I mean, after we had gone through so much in terms of the battle to end discrimination, and the American people were at a position where they felt that we shouldn't permit our taxpayers to be funded for discriminatory purposes. I think my time is over. I think the chairman might give you 15 seconds or something to respond, if you could.
Senator, what's come out so far is this man is obviously a nice fellow. People like him. He's a very, very bright, if not brilliant, jurist and an extremely thoughtful lawyer. But he has certain ideological predispositions. He has values. Those values are way to the right of the mainstream in America. I don't think there's any question about it. And so it is up to all of you to decide whether you want to put somebody in as Chief Justice who's that far to the right. I think it's as simple and direct as that.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. Senator Sessions?
I see Senator Hatch left, but here's the stop Souter women will die ad. This group found, so I guess that did not prove to be a good prediction, except a lot of women partially born have died since Justice Souter went on the court.
Make that a part of the record, Senator Sessions?
Yes, I would offer that for the record.
Without objection.
I think, Mr. Reich, that Judge Roberts has a value that he's expressed articulately, beautifully, repeatedly, that he loves the law. He loves the court, and he believes a court has a role to be a neutral arbiter and not to impose its personal views. And I don't think that's a man, I don't think he brings that because he may be politically conservative and believes in lower taxes or whatever he believes in politically. I think that's his deepest and highest value that was repeatedly stated here many, many times, and I think that's exactly what we need in the courts of America today. And I think the people of this country will be more respectful of the court if the court returns to that role. That's my personal view. Ms. Thistlethwaite, I've tried to think over the years about appropriate approaches to the church-state issue. Methodist myself and been involved in some of these things. I see you're a liberation theologist or so, but let me say this. You've expressed some pretty strong views about the need for a wall between church and state, and just yesterday the Supreme Court a district court, following what he thought was the command of the Ninth Circuit, ruled that the Pledge of Allegiance, which has "under God" in it, is unconstitutional. Do you have an opinion about that? I think it's in some ways consistent with some rulings in the Supreme Court, as I shared with Judge Roberts, and I think it's perhaps inconsistent with others. How do you feel about the wisdom of having those words in the Pledge of Allegiance?
Well, I'm very interested, Senator Sessions, to know whether you think people will be increased in their faith if they just say those words repetitively. I don't know what the goal is if it is not to establish a deistic religion. Because if it is to include the words so that they can be historical, as I'm citing from the founders, you know, God doesn't need your help. So if it's historical, that was added to the Pledge of Allegiance. It was not even original in the pledge. I look at the people out on the street demonstrating. They seem to feel, the people in favor, after the press show us the pictures of people demonstrating after this decision was made. And the people seem to feel it is prayer. And if it is prayer, then I think it's unconstitutional.
Well, what about, I guess you would further say that we should take "In God We Trust" off the coins?
Do I think it's a good idea to confuse Caesar and God? No, I don't. Render unto Caesar what is Caesar, and what is God, what is God's. I don't think that's a good idea.
You would oppose, then, the chaplain of the United States Senate?
Pardon me?
You oppose the position of chaplain in the United States Senate?
Do I think you all need spiritual guidance?
That's part of it, perhaps.
I think it's okay if you rotate it around. But I'm not the constitutional lawyer. I'm a pastor.
Well,
I'm kind of in favor of pastoral care. So.
Well, I would say this. I think that it is an absolute truth that our government was founded on a principle that we are created beings with certain inalienable rights. And when you get in a secular, like the Marxist ideologies, that they have no respect for life, not the same degree of it, and I think it's a unique portion of our great American spirit that every human being is respected, specially because we believe they were created, and it, such words as "under God" or "in God we trust," I think are not sectarian. I do not believe they establish a religion, but it simply reflect a consensus view of probably 90% of Americans that there is a higher being. And I think that the Supreme Court authorities on these matters are somewhat strained and confusing, and perhaps Judge Roberts can improve that. I certainly hope so. I see my time is up. Thank you, Mr. Chairman.
Thank you, Senator Sessions. Senator Coburn, you have the last word.
Thank you. Thank you, Mr. Chairman. And since I do, I would just like to compliment you and Senator Leahy.
I'm sorry we can't hear you.
I'll say it again and again and again. If my budget's increased, I'd be happy to say it. But as a freshman senator, the way this hearing's been conducted, the leadership that you, Mr. Chairman, and you, Mr. Leahy, have conducted it under, I think is reflective of good qualities of the United States Senate and the country. And it kind of leads me to the questions that I have, especially for Dr. Thistlethwaite, is the last statement that you said, you're not convinced that John Roberts believes in the dream of America. Mm-hmm. And I'm just wondering, could anybody of conservative values believe in that dream? Is it possible? Because and I don't know John Roberts' actual answer, but I go to bed at night worrying if he's on the Supreme Court. I have completely opposite views than Planned Parenthood, certainly about reproduction and other issues. But the question is can somebody have values different, conservative values, and believe in the dream of America and be a good judge? Is that possible?
Yeah, I was very impressed by the gentleman who spoke last on the last panel, who was testifying to the fact that the definition of the word conservative has changed.
Well,
And I
I don't
think
want to get into a discussion about the definition of conservative. I'm a known quantity, all right? I'm a known quantity. People know my opinions. I'm not very quiet about them, sometimes to my own ill benefit. But the fact is it talks about what Senator Kennedy talked about and Senator Feinstein, is do they have a heart? And the question is can somebody have a set of values that are different than what you perceive to be okay for the American dream and still have the heart of a Senator Kennedy and make a good judge? And I'm very confused about what I consider a very inflammatory statement about Judge Roberts in your closing. Because what it does is it castigates people into categories, the very thing Jesus said we don't do. To me, it's concerning that we have this decision that we've already decided how he's going to decide. Well, I want to tell you, I spent 2 hours with him, and I'm as pro-life as they come, and I can't tell you where he's going to be. And I tried to find out. And if I spent 2 hours with him, how in the world do you all know that he's not going to be? And how do you know, based on the history of the judges that have come before this committee before, who the same claims were made about and the opposite results came about? And I think it undermines the testimony. And I think it lends for us to go back and reconsider as a nation, all of us, the people I represent, the viewpoints I represent, and the viewpoints you represent, is that maybe we don't know people's heart as well as we think we do when we speak out to make such a charge that John Roberts, you're not convinced he believes in the American dream. Well, I'll tell you what, I'm convinced he does. And I'm also convinced that he's got a great heart. And I've spent hours upon hours here, and I spent hours with him, and I spent hours upon hours reading everything that has been brought up about John Roberts. And I think he's got the heart for the American dream. And I would hope, and I'll close where I ended, what we need in our country is more pulling together rather than pulling apart. And certainly, if that can happen anywhere, it can happen in our country. And I'll dedicate myself to try to do that on everything but spending. I'll make that exception. But I'll work to pull together, because we're not really all that far apart. We're not that far apart. But we magnify and enlarge the areas where we are apart. And the love from the Almighty, that's what he wants in front of us. And it's my hope as we finish and the things that we do in this committee in the future, and John Roberts' career, whatever it's going to be, will be a manifestation that he believes in the dream. Thank you, Mr. Chairman.
May I
Thank
reply?
you very much, Senator Gorman. Dr. Thistlethwaite, you want to make a comment? Yes, go ahead.
I wish I had been able to see more than 10%. And it was said 10% is approximately the documents. I wish that we had been able to see more. I was hoping that the hearings would reveal more. But I can only tell you what's in my heart, and that is that the dream of the Constitution, that it does protect, that it is about the little guy, I am not convinced. And you asked me to tell you what I think, and I tried to do the best I could.
Thank you very much, Dr. Thistlethwaite, for your comments. They're obviously very, very deeply heartfelt. And I think that's been reflected in these hearings very, very extensively. Thank you, panel, for your very profound testimony. We have had 30 witnesses in today who have been very profound, excellent, insightful. I want to thank my colleagues for their attendance. We've worked in 4 days to take on an arduous task, and we've worked late, Tuesday, Wednesday, and Thursday into into the evenings, and the attendance here, based on the experience I've had on this committee for 25 years, the attendance has been excellent because senators are very, very busy. Everybody has a half a dozen places where he or she has to be at any time, and the attendance has been really very good. And I thank especially Senator Leahy for the leadership which he has provided. We have conferred at every step of the way and have had agreement at virtually every step of the way. And where we haven't had agreement, it has been a very amicable agreement to disagree, and not on the big points. So the big points we've come to terms. I want to thank Mike O'Neill, the Chief Counsel, and Bruce Cohen, Chief Counsel for Senator Leahy, and the staffs. Staffs in the Judiciary Committee didn't have an August. They can pluck August right off the calendar. And they examined 71,000 pages of documents, and they're used to all-nighters because they're all students and scholars. But they had a lot of all-nighters, so I thank the staff for doing that extraordinary job. I think it's not inappropriate to say that Senator Frist, the leader, has commented about the many good reports he's had at a time when the Congress has been under a lot of scrutiny for the hurricane and a lot of problems that it can be characterized by others. We were asked to conduct dignified hearings, and except for very minor occasions where the witness might have been permitted a little more opportunity to respond, it's been very, 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 very smooth sailing. So I'm appreciative as the chairman for what we have done. Before yielding to Senator Leahy, I would ask unanimous consent that documents be included in the record, and the record will remain open for 24 hours so that questions can be submitted, and then we'll be moving ahead to an executive session by agreement on the 22nd, week from today. And Senator Leahy and I are in agreement on trying to keep the speeches short, long statements for the record, but to 10 minutes if we can, providing that leadership. All those senators have their own rights, and we don't want to impose upon them, but where we have tried to establish time limits, there are 17 senators in this committee who like to see the 18th observe the rules. All of us are willing to take some cutback when we've been able to move with dispatch and get our business done. Senators, we are a notorious group. People want to know when we're going to finish this hearing today, and I said earlier, when the last senator stopped speaking. Now I'm stopping.
I think that's a hint to me. I want you to know, first off, it has not been totally happy. On this side, we wanted to go through tomorrow and Saturday, Mr. Chairman. We're terribly disappointed you didn't make that possible. And, of course, Governor Engler knows what we're saying. To be serious, it is a serious matter. I want to compliment the key witness, Judge Roberts, saying here we did ask him a lot of questions. Some he answered, some he did not. He knows our feelings on both sides of the aisle on that. He spent, I know, almost 3 hours with me, and he spent hours upon hours with other members on both sides of the aisle. How we'll vote, I mean, I have no idea how I'll vote. I suspect I'll probably be announcing it at some time prior to our hearing, but by Thursday, I and the others on this committee will have to vote. I think we have as strong a record as we're going to have, and I compliment the chairman in that regard, and I compliment both his chief of staff, Mike O'Neill, and mine, Bruce Cohen, for this. But the people, the chairman was right in mentioning those who worked throughout August. I came down here during August and checked on what they were doing. It was extraordinary. I know from the voters came out to my farm in Vermont almost every other day that they were making sure I knew what they were doing and that I would work with them. But it is extremely important for the country. I don't come into this with a preordained idea of how I'm going to vote. I do want to vote, though, in what is best for my country. I do love my country. I wouldn't serve here if I did not. My maternal grandparents came to this country from another country not speaking the language. Both my grandfathers were stone cutters. Both would be proud that I had the opportunity to be here. It is a great opportunity. I don't take it lightly. We have said several times, it's only 101 people who get to speak for all 280 million Americans on this. The president, when he makes a nomination, the 100 senators. I think the 100 senators have to make the best decision possible. We have a great duty here in the advice and that we will give the rest of the Senate. I don't take that lightly. I do compliment the chairman. He and I have talked many, many times through this. He has accommodated the wishes of people on my side of the aisle as he has on his side of the aisle. And we'll find out Thursday how we're going to vote. And I appreciate the panels. Many of you have sat through here all day, a long time. I know many of you very well. I know how busy your schedules are. I appreciate you being here. Thank you, Mr. Chairman.
I saw Judge Roberts briefly in the hall, and he looked much relieved. I thanked him for his good humor. It's a great tribute to our Constitution. The President nominates, the executive branch works in, and the legislative branch in our committee here, and later the full Senate and the judiciary. It's a great separation of power and great coordination. It's a great privilege to be a part of the system, and that concludes our hearing.
Okay, thanks.
4 days of confirmation hearings for John Roberts as U.S. Chief Justice. We're going to keep our eye on a camera position that we have outside of the hearing room you may have seen, in case any of the senators or proponents or opponents of the nomination care to speak. Committee will be meeting, as you heard, in 1 week from today for a vote on John Roberts, and we'll have coverage of that on the C-SPAN networks. Senators can still submit written questions to John Roberts if they like. And if you'd like to see any part of today, all told, without the breaks, it ran about 7 hours, 45 minutes. We'll show that tonight on C-SPAN 2, starting at 9 p.m. Eastern Time. Now, the nomination could come to the Senate floor the week of September 26th. That's not next week, but the week after. And the following week is when the new Supreme Court term begins, on October 3rd, Monday, October 3rd. Coming up this weekend, we will look back at this week's confirmation hearings, both on Saturday and on Sunday, on our companion network C-SPAN, starting 10 a.m. Eastern Time each day.